by the continued defiance on the part of the HOR. Parang tayo po ay tila nagmamatigas.
Ito ang matapang na pahayag ni Representative Marcoleta, kaugnay ng tila pagmamatigas ng House of Representatives sa naging desisyon ng Korte Suprema na unconstitutional ang impeachment laban kay Vice President Sara Duterte.
In a unanimous decision today, July 25, 2025, the Supreme Court en banc declared the articles of impeachment against Vice President Sara Duterte unconstitutional.
Matatandaan na sa botong 19 at 5 ay tuluyan ng na-archive ang impeachment sa Senado bilang pagtalima na din sa pasya ng Supreme Court. Di rin nakaligtas kay Representative Marcoleta ang mga naging pahayag ni Speaker Romualdez sa mga mahistrado.
Members like the President and the Vice President are also impeachable officers. When the court lays down rules for how it or others like it may be impeached, it puts itself in the dangerous position.
Nakarinig tayo ng mga pahayag mula sa House members na tila baga tinatakot ang ating mga maestrado na pwede kayong ma-impeach din.
Agad namang kinontra ni Representative Libanan ang mga naging pahayag ni Marcoleta at iginiit na walang defiance sa House of Representatives.
I beg to disagree with that statement. Wala pong defiance ang House of Representatives.
Sa huli ay lalo pang uminit ang sagutan ng dalawa.
To substitute the word defiance if the body will so allow.
With the permission of the majority leader,
Mr. Speaker, it was my time. It was only availing of my time.
Yes.
The honorable gentleman has not been recognized. They have not taken my seat.
For the record,
Panoorin pa natin ang buong detalye. Pero bago yan, huwag kamlimutang mag-like at subscribe para sa mga pinakabagong balita.
Distinguished Minority Leader will yield to a few questions and to make a manifestation from his speech. Thank you.
I will gladly accommodate request of...
Honorable Marcoleta is recognized.
Mr. Speaker, you enumerated earlier that the Supreme Court has added new rules on impeachment, specifically the furnishing of a copy of the articles of impeachment along with the evidence, pieces of evidence to the one impeached. Is that correct, Mr. Speaker?
That is correct, Mr. Speaker.
And along with that, you also said that each signatory to the impeachment complaint should have read in its entirety the articles of impeachment before signing it. And in your own opinion, it is another rule added by the Supreme Court.
That is what the Supreme Court stated, Mr. Speaker.
And our distinguished colleague, Ma'am Laila de Lima, said that due process is not needed here in this particular case. But in my personal opinion, Mr. Speaker, due process is intrinsically embedded in all judicial, even administrative processes. It need not be construed specifically in the Constitution. Halimbawa po, kung tayo ay magtatanggal ng empleyado sa kumpanya, kahit wala naman pagtatangka sa kanyang buhay, we also accord due process to the person that we are about to remove from office. Usually, tayo po we ask for an explanation letter dun sa empleyado kung bakit niya, why he or she has breached a company policy. In other words, meron pong due process. And I think it need not be specifically stated in every ruling. And I think dapat po talaga intindihin natin ang due process ay nandyan, nananalaytay sa lahat ng ating mga batas.
Mr. Speaker, ang impeachment po ay a class of its own. May tinatawag na substantive due process, procedural due process, administrative due process. At dito naman sa impeachment, sinasabi po ng kanina sa interpellation na ang process na ito, pag pumirma ang 1/3 of all the members, hindi naman nawawala ang sabi, wala dito yung due process dahil ang penalty dito, sabi po ng Honorable De Lima, ay removal from office, ang pinaka-harsh na penalty. Hindi yung katulad sa criminal or administrative. Pero, Madam Speaker, dagan ng impeachment po ay pag pumirma po ng 1/3 of all the members of the House at sinumiti po ito sa Senado, nandoon pa rin ang due process. Kasi doon po ay may karapatan makinig at hear yung mga depensa po ng ini-impeach.
Opo. Kung ito pong impeachment ay alang-alang sa accountability, hindi po ba dapat natin habulin ang Vice President sa Ombudsman at sa ibang mga korte? Sapagkat sa tingin ko, kung ang sanction lang ng impeachment ay tanggalin ang Pangulo sa kanyang pagkakaupo, hindi po siya mananagot ng maigi dun sa kanyang alleged misuse of confidential funds. Di ba dapat managot din siya sa kanyang di umano idinispalto na pera? Di po ba? We should seek other remedies like cases before the Ombudsman at ano pang mga korte.
Madam Speaker, yung privilege speech ko po ay hindi po tungkol sa paghahabol sa Vice President. Ang privilege speech ko po ay tungkol po sa desisyon ng Supreme Court na gumawa po ng maraming requirements sa House of Representatives tungkol sa impeachment na exclusive power of the House of Representatives. Ganun po ang aking binitawang privilege speech, Madam Speaker.
Just to reiterate, the topic of the Honorable Marcelo Libanan, our Minority Leader, is Senate action to archive the impeachment case of Vice President Sara Duterte.
Mr. Speaker, distinguished Minority Leader, yung po bang sinabi ng Korte Suprema ay are we being precluded to initiate impeachment complaints or we're just being taught on how to file a correct impeachment complaint by complying with procedural steps? Tayo po ba binabawalan talaga ng Korte Suprema o tayo tinuturuan lamang kung paano maghain ng tamang impeachment complaint?
Before the Minority Leader responds, since the question of the Honorable Marcoleta is directed towards the action of the 19th as well as the 20th Congress, may we request the Senior Deputy Majority Leader to respond?
Madam Speaker, we appreciate the exchange of the gentlemen regarding impeachment as well as the decision of the Supreme Court. I be allowed to raise a point of order, Madam Speaker?
May we know the point of order of the Majority Leader?
Madam Speaker, the discussion has been towards whether or not the House can exercise certain powers, especially in initiating impeachment complaints. However, may I remind our members that we have a pending motion for reconsideration with the Supreme Court. Thus, we cannot discuss the same with finality this afternoon during the privilege hour. May I request the gentlemen if we can hold further deliberations, heated deliberations in the future so that we can wait until our motion for reconsideration has been decided with finality by the Supreme Court.
What does the Honorable Marcoleta say?
May I proceed with my manifestation, Mr. Speaker?
Madam
Majority
Speaker,
Leader.
can we let the Honorable Marcoleta finish his manifestation before we proceed to the next speaker to avail of the privilege hour? Thank you, Madam Speaker.
Majority Leader, I believe the Honorable Libanan as well as the other members of the House are actually, we have 22 members listed for the privilege R.
That's right, Madam
Yeah,
Speaker.
so I believe a manifestation can be taken up at the appropriate time once the privilege R has been closed.
Madam Speaker, I have already registered my intention to make a manifestation.
Madam Speaker, a manifestation would be in order. Let's allow the Honorable Marcoleta to finish his short manifestation before we conclude the privilege speech and refer the same to the Committee on Rules.
The Majority Leader's request is hereby granted.
Thank you, Mr. Speaker. Sa pagtatapos po ng 2024, sinabi po ng ating mahal na Pangulo na ang impeachment ay hindi importante. Sabi niya, this does not make any difference to any single Filipino life. So why waste time on it? And despite the admonition of the President, the House, through one-third vote, transmitted the articles of impeachment to the Senate. Why didn't we heed the call of the President? Why did the HOR defy the President's pronouncement? Gusto ko lang pong malaman kung bakit ganon. Parang hindi natin sinusunod ang mga pahayag ng ating Pangulo.
Before the Honorable please proceed.
At nung July 25, the Supreme Court, sabi nga nila, inilang dineklara ng articles of impeachment ay unconstitutional at void ab initio. At pagkatapos noon ay nakarinig tayo ng mga pahayag mula sa House members na tila baga tinatakot ang ating mga maestrado na pwede kayong ma-impeach din tulad ng Vice President. And despite the motion for reconsideration submitted, the Supreme Court, through a press briefer, reiterated that the decision is immediately executory, notwithstanding the MR. And the Senate accordingly adhered to the decision by archiving the articles of impeachment. So ang tanong ko lang po why the continued defiance on the part of the HOR? Parang tayo po ay tila nagmamatigas. Samantalang ang Korte Suprema at ang ating co-equal body ng Senado ay tumalima na sa sinabi ng ating Korte Suprema. Alam naman po natin that the Supreme Court is the final arbiter on all disputes and controversies pertaining to constitutional issues. And the decisions released by the Supreme Court form part of our legal framework, form part of our legal system sa ating bansa. Dapat po nating galangin ang ating co-equal branch. Sinabi din po ng Pangulo sa isa sa kanyang mga panayam at huli-huli sa kanyang sona ng Pilipino ay sawa na sa sobrang pamumulitika. So, buti pa ang ating Pangulo aware dito. At siyempre, kamakailan ay meron pong ibinalita na meron na naman pong Quadcom version 2.0. Alam naman po natin ang Quadcom ay nagagamit bilang political persecution more than a tool for legislation. At pinakita pa nga po ng Quadcom sa kanilang performance last year that it assumed judicial and prosecutorial roles which is beyond the ambit of its legislative function. Mr. Speaker, the continued defiance of the House of Representatives has been truly remarkable. Sana naman po ay baguhin na natin ang ating estratehiya. Sa akin lang naman po. Dahil ako'y miyembro ng 20th Congress, bakit hindi po natin baguhin or reassess ang ating strategies? Kaysa bumabakbak tayo ng bumabakbak ng ating political adversaries. Bakit di na lang po natin galingan? Total, meron naman po tayong 3 taon pa para ipakita na tayo ay mahusay din sa pamamalakad. Ang akin lang naman po, this administration has been characterized by, treating its political adversaries na pag malakas ang kalaban, i-disqualify, i-expel, i-impeach, or i-threaten na i-impeach. Bakit hindi lang naman po natin galingan? Meron pa naman po tayong 3 taon. Baka sakali, matalo natin si VP Sara sa 2028. Maraming salamat po.
Madam Speaker, there being no other
Madam
member
Speaker.
who wishes to interpolate, I move...
Still my time, Mr. Speaker.
The Honorable Nonoy Libanan may proceed with his privileged speech.
Mr. Speaker, kung magpasalamat sa manifestation na magamat mahabang manifestation ni Congressman Marcoleta. Pero yung sinabi po niya na may defiance ang House, parang narinig ko na may defiance ang House sa Supreme Court ruling. I beg to disagree, Honorable Marcoleta, with that statement. Wala pong defiance ang House of Representatives. May motion for reconsideration po tayo. At kung sakali, I don't think ang House ay hindi susunod kung final and executory na ang ruling ng Supreme Court. Pero may oras pa tayo. At ito, ang chamber na ito ay ang precise venue to air our grievances. We represent all the people here, especially we in the minority. Ito yung mga bagay na dapat ilabas po natin dito because this is our constitutional duty. Obligasyon natin proteksyonan ang ating duties and obligations. As a House, obligasyon po natin palakasin ang House of Representatives dahil ito po isa sa matibay na pagbalansin ng power. Kung sobrang tapang ang Supreme Court, sobrang tapang ang Executive at mahina ang House, palagay niyo po ba tatayo ang ating bansa? Kaya lahat po tayo obligasyon patibayin ang kanya-kanyang mga sinumpaang tungkulin. May duties and obligations po tayo at kahit po masakit, kahit mahirap, kailangan natin ipaglaban ang ating konstitusyon. Yan po ang napakahalaga sa lahat. Maraming salamat po, Madam Speaker. Maraming salamat po sa aking mga kasamahan po. And if I may move, Madam Speaker, I would like to erase from the record the statement of the Honorable Marcoleta that defiance of the House of Representatives, hindi po tayo defiant. So move, Madam Speaker.
There is a motion to delete from the records the statement, the House is in defiance. Do I hear that right, Minority Leader? So any attribution to the statement of the Honorable Marcoleta stating that the House is in defiance of the Supreme Court ruling is hereby deleted. Majority Leader.
Mr. Speaker, I am amenable to substitute the word defiance if the body will so allow.
With the permission of the Majority Leader,
Mr.
what's
Speaker.
the
It was my time. He was only availing of my time.
yes.
The honorable gentleman has not been recognized. They have not taken my seat.
For the record, we are in the privilege hour. The Honorable Nonoy Libanan has his time.
Thank you, Mr. Speaker. Speaker, esteemed colleagues, good afternoon. As early as the second half of the 14th century, the concept of impeachment emerged in England as a means of holding high officials to account for misconduct. In 1787, it was adopted into the United States Constitution, granting the House of Representatives power to impeach and the Senate the power to try impeachments. The United States later introduced impeachment to the Philippines during the Commonwealth period through the 1935 Constitution. This framework adopted the U.S. model, specifying the grounds for removing the President, Vice President, Justices of the Supreme Court, and the Auditor General. It granted the House the power to impeach by a two-thirds vote and the Senate the power to convict by a three-fourths vote. While the 1935 Constitution laid the foundation, the 1973 and the 1987 Constitutions refined both the process and the grounds for impeachment. The 1973 Constitution, under a parliamentary system, gave the National Assembly the exclusive power to initiate, try, and decide all cases of impeachment against the President, Supreme Court justices, and the members of the constitutional commissions for culpable violation of the Constitution, treason, bribery, other high crimes, or graft and corruption. The 1987 Constitution, which restored the bicameral Congress, preserved impeachment under Article 11, Section 2 and 3. It specifies the impeachable officials, the exclusive power of the House to initiate, and the sole authority of the Senate to try impeachment cases. It likewise grants both chambers the constitutional right to promulgate its own rules to govern impeachment proceedings. For 90 years, this system stood. But on July 25, 2025, the Supreme Court of the Philippines rendered its decision in Duterte versus House of Representatives, GR number 278353, and changed the course of our constitutional practice. Mr. Speaker, I will not belabor the chorus of voices calling the decision gravely erroneous in fact and in law. Rather, I will focus on its adverse effects and ominous consequences to our constitutional duty to demand accountability from high officials. The decision not only declared void ab initio the plenary-approved articles of impeachment against the Vice President Sara Duterte, transmitted to the Senate on February 5, 2025, it also ruled that she was denied due process under the Bill of Rights. The court held that due process applies at all stages of impeachment and imposed 7 new due process requirements on the House. Per Supreme Court decision in Duterte versus House of Representatives et al., GR 278353, July 5, 2025, due process requirements in impeachment proceedings are as follows. Number 1, the articles of impeachment or resolution must include evidence when shared with House members, especially those who are considering its endorsement. Number 2, evidence should be sufficient to prove the charges in the articles of impeachment. Number 3, the articles of impeachment and the supporting evidence should be available to all members of the House of Representatives, not only those who are being considered to endorse. Number 4, the respondent in the impeachment complaint should have been given a chance to be heard on the articles of impeachment and the supporting evidence to prove the charges prior to its transmittal to the Senate, despite the number of endorsements from House members. Number 5, the House of Representatives must be given a reasonable time to reach their independent decision of whether they can endorse an impeachment complaint. The court, however, has the power to review whether this period is sufficient, but petitioner who invokes on the court's power to review should prove that officials failed to perform their duties properly. Number 6, the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during their current term the current term of the impeachable officer. For the President, the Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 2, a betrayal of public trust given by majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and underweight the respect of their constitutional independence and autonomy. Number 7, to ensure that respondent in the impeachment complaint is heard under the requirements of due process in the procedure under Article 11, Section 3, to Paragraph 4, the House of Representatives is required to, letter A, provide a copy of the articles of impeachment and its accompanying evidence to the respondent to give him or her an opportunity to respond within a reasonable period to be determined by the House rules. The Constitution only requires an opportunity to be heard. It is up to the respondent to waive this fundamental right and opt to present his or her evidence at the Senate trial. And letter B, make the articles of impeachment with its accompanying evidence and the comment of the respondent available to all members of the House of Representatives. It is the House, not 1/3 of the House, that has the sole prerogative to initiate impeachment complaints. Thus, there must be some modicum of deliberation so that each member representing their constituents can be heard and thus convince others of the position. That transmittal, however, will only take place upon the qualified vote of 1/3 of the House. That was the decision of the Supreme Court on the 7 requirements, Mr. Speaker. These requirements are nowhere found in the Constitution. They amount to a direct intrusion into the House's exclusive constitutional authority to adopt its own impeachment rules. Many call this judicial overreach. I say it is judicial amendment of the Constitution. The right of the House to promulgate its own rules is clearly and plainly stated in our fundamental law. It is not for the Supreme Court to write rules and for the House to follow. The judiciary has the vital role of interpreting laws, including the Constitution. But that role does not extend to amending it. The power to interpret does not include the power to rewrite, Mr. Speaker. Yet, the decision effectively rewrote our impeachment rules, imposing requirements that are impractical, if not impossible, to fulfill. First, it mandates the House furnish the respondent with the articles of impeachment and supporting evidence to allow them to respond before transmittal to the Senate. But the Constitution requires referral to the complaint to the proper committee within 3 session days, an impossible time frame for debate, notification, comment, and hearing. Failure to meet this deadline renders such proceedings unconstitutional. Second, it requires that articles supporting evidence and the respondent's comment be made available to all members. This opens the process to sabotage. A single member could invalidate proceedings simply by claiming they were not furnished or did not understand the documents. Such a scenario could not have been intended by the framers. Third, it holds that mere filing of an impeachment complaint, acted upon or not, constitutes initiation and triggers the 1-year bar. This dangerous precedent allows a crony to file a frivolous complaint the moment the bar expires, effectively shielding an impeachable official from real accountability year after year. The cumulative effect of this pronouncement is to ensure that impeachment against the Vice President and future impeachments against any official will not survive. One must ask, did the members of the Supreme Court wittingly or unwittingly shield themselves from impeachment? Let us remember, the last impeachment case before the Vice Presidents involved a sitting Supreme Court justice. Mr. Speaker, the Venerable Senator Claro M. Recto, principal drafter of the 1935 Constitution, must be turning in his grave. But not all is lost. The people's right to demand accountability from their highest officials must remain our guiding principle. This decision, while formidable, is not an insurmountable barrier. We must explore every avenue, navigate every obstacle, and take even the narrowest path to fulfill our constitutional duty. This House shall not bow in silence. The House has already filed its motion for reconsideration. The Honorable Supreme Court still has the opportunity to rectify its ruling, to issue a decision aligned with the facts, the letter and spirit of the Constitution, the principle of separation of powers, checks and balances, established precedent, and most importantly, the people's right to demand accountability. Thank you, Mr. Speaker.